Hello everyone, hope you're having an amazing day. Now in this session, let's jump onto a brief explainer about types of trademarks and grounds of refusal for trademarks under the Trademarks Act of 1999. Now there are different types of trademarks that can be registered in India. So first of them is word marks and they are the most common type. So they include letters or words or numbers. For example, Amul, Nike, or sometimes even abbreviations like IBM. So these are word marks. Now, after that, there are certain device marks or logos which are style representation. Like a very common example that we have also discussed before is that of Apple's button logo or McDonald's yellow M over a red background. Then after these two, we have certain shape marks. So this covers the arena of different shapes of goods and packaging. For example, the Toblerone bar. It has a connected pyramid shape. So when you look at that chocolate and even if it does not have the word Toblerone written on it, you'll know that it is that chocolate only because of its distinctive shape. Or, of course, another example that we have discussed before is that of Coca-Cola's contoured bottle shape. Then, after this, sound marks are also recognized in India. For example, sound like, Airtel's jingle or Nokia's tune. So, whenever you hear them, you know which company it represents or which organization it represents. Then after these four, the next one is color marks. Now these are a bit trickier, but if there is a specific color used by a certain brand or a certain organization and it has been used so often that it has acquired a certain distinctiveness, then it can be registered as a color mark. For example, like we have talked before, Cadbury chocolate's purple color is sort of distinct. So whenever you look at that particular shade of purple, you can think of course, Cadbury's chocolate. Or one more famous example is that of Tiffany's blue. Then after that, there are certain series mark as well, which protect a family of marks. So the best example to understand this one would be that of McDonald's McChicken or McVeggie or McSpicy. So whenever you hear the word or the prefix Mc, you know that it refers to McDonald's. So the prefix Mc in each of these food products has acquired a certain distinctiveness, and it can be covered under the series mark. Then finally, there are collective marks and certification marks. So collective marks are used by some associations like, ICAI for chartered accountants, and certification marks, they guarantee standards. Like we have talked about before, there are certain ISI marks like AG mark or wool mark or hallmark. Okay, so these are that. Then after that, let's talk about certain grounds of refusal for acquiring trademarks. Okay, so under the Trademarks Act of 1999, we must understand that not all trademarks can be accepted, and there are two major categories for refusal. The first one is absolute grounds, and the second one is relative grounds. So, under Section 9, when we talk about absolute grounds of refusal, then it covers certain prerequisitions like lack of distinctiveness. So, your mark is either too generic or if it's too descriptive, then it won't qualify. For example, if you try to register the word milk as a trademark for dairy products, then it would be rejected because the mark must distinguish goods or services of one trader from that of the other. Then the second prerequisite is that marks that describe certain quality, quantity, or nature of goods, they also face rejections. For example, if you call a soap soft and white as descriptive and it's not too distinctive, right? So it can be rejected. Then the third prerequisite is that your trademark is either deceptive or confusing, or if it misleads the public about its nature, quality, or origin, then your trademark can be barred. Then the fourth one is marks that go against morality or public policy. So if your mark is either vulgar or offensive, then of course it cannot be registered. Then the fifth one is religious sensitivity. So marks that hurt certain religious sentiments of a community or a community in large, they are not allowed. And the last prerequisite here is marks that use certain symbols or emblems that are registered nationally. So if you use the national flag or emblem or names like Mahatma Gandhi without any prior approval, then your trademark will not be registered. Then after that, section 11 covers the relative grounds of refusal. So these grounds, they focus on conflicts with existing trademarks. All right. So first of that is likelihood of confusion. So if your mark is identical or if it is deceptively similar to another existing trademark, then it will be refused. Also, a very good example that we saw in the last session as well was that of Cadila Healthcare Limited versus Cadila Pharmaceuticals Limited of 2001. And you know how it talked about two anti-malarial drugs, Falsigo and Falsitab. And after that, Supreme Court laid down certain tests to understand and point out deceptive similarity. And you know, certain elements that were used to identify deceptive similarities were phonetic similarity, nature of goods, consumer base, purchasing habits, so on and so forth. Now, the second prerequisite when we talk about relative grounds is if someone tries to register a mark that is identical or similar to a well known trademark, even if it belongs to a different industry. And it can be refused under this prerequisite. So, if you own a clothing brand and you name it Google, so even if the original Google and your request of the name Google, even if both of these belong to different sectors, it will still be rejected. And a case example to understand it is this one. This is from 1994, and here the defendant used the word Benz for undergarments, and the court restrained it because, of course, the word Benz reminds anyone of the car Mercedes Benz, right? So, of course, famous marks deserve extra protection, and even across unrelated goods. Then, the third prerequisite is that of association with earlier marks. So, if the new mark is capable of diluting or tarnishing the image of an existing mark, then it can be refused. Okay. So, basically, when the trademark registry examines an application, they have to look at both the angles. So, the first angle here is whether the mark is inherently registrable, which is known as the absolute ground. And the second one is, you know, whether it clashes with any existing rights or any existing registered trademark, which is known as relative grounds. So these decisions are heavily shaped by previous case laws, and Indian courts have also consistently stressed about consumer protection and how it is an underlying principle. So this law, it aims to prevent confusion, deception, and unfair advantage. So to recapitulate, trademarks in India, they cover a wide range. So it can include words, logos, shapes, colors, but this registration is not automatic, and you know, the mark, it has to be distinctive, it has to be non-defective, and it should not be conflicting with any existing mark. All right. I hope you were able to understand today's topic. Thank you so much for tuning into today's session. My name is Bhargavi and this is Vaquill.